Hello, hi, and welcome. So, now this is the first topic in corporate and other laws, third chapter. So, the topic is that what are the different modes of securities issued by public and private companies? So, students here, the information is given in nutshell in a small and simple diagram, which is very simply understand and easy to remember. The various modes of issue of securities by public companies or private companies. So the question may be likely to be asked on this topic is that what are the various modes of issue of securities by public companies and the private companies under the Companies Act 2013. So if a question comes in this fashion, a student have to write what is what do you mean by public company and what do you mean by a private company. And here there are four modes of issue of securities by a public company. And what are the four modes, and you need to describe it in brief. And when it comes to prospectus or a public offer, in case of a public company, can be of another three different kinds like IPO, FPO, or OFS. Now, if you come to the topic, public companies or the private companies do issue or do go for the capital either from the general public in case of a public company or from the closed network within the maximum limit of number of members. In case of a private company, they can acquire capital after floating a company. So the advantage of a floating of either public company or a private company is that it can acquire capital from its members. And in case of a public company, the availability of capital base is broader. So it can acquire its required capital by issuing a prospectus. This is the first mode of acquiring capital in case of a public company by issue of securities. So prospectus means nothing but a public offer. We also can call hereafter as a public offer, which means to say it is a prospectus, which is an advertisement, which is issued under the provisions of the Companies Act to general public to offer to submit offer for subscribing the shares of a company. So this offer to the public can be of three different kinds. The first one is IPO. IPO means initial public offer. Once a company gets incorporated, for the first time it offers its securities to the public by issue of prospectus, then it is called as initial public offer. And second one is further public offer. So after the initial public offer, if company goes for acquiring further capital for its business requirement, such an offer is called as further public offer. And the third one is that offer for sale of securities. Offer for sale of securities, OFS. So this OFS, which mean to say offer for sale of securities, will be done by a shareholder of the company. So this is The technical difference a student must understand the difference between IPO, FPO and to that of OFS. Initial public offer and the further public offer. These both will be made by issue of prospectus by the company to the general public. And here the company will sell the shares to the public. When it comes to OFS, offer for sale of securities, here the securities of a shareholder will be sold to the general public by issue of prospectus by the company. Dear students, you need to understand the technical difference between IPO, FPO and to that of OFS. IPO, FPO will be the sale of shares by a company, and OFS is the sale of securities or shares by a shareholder through the company by issue of prospectus. This is the very simple difference a student have to understand clearly. So the second mode of issue of securities by a public company is the private placement. Private placement in general, students, here you have to understand if the requirement of capital is very minimal, and the promoters of the company, if they have a broad range of contacts and a inner circle, if they want to offer the securities of that company to the selective people and within the inner circle, then such a offer is called a private placement. And this private placement will give capital in the initial stages to a public company, whatever that is needed to commence its operations. In general, in general, most of the companies will go for private placement initially and will acquire some capital, and thereafter if their capital requirement is very huge, then they normally will go for IPO. So when it goes to IPO, the offer is open to everybody. When it comes to a private placement, there is a discretion to the company to whom the shares are to be offered and to whom the shares are not to be given. So such a facility will be giving a public company an opportunity to keep their near and dear who are having the equanimity of mind while carrying the business of the company in near future. And the third mode of issuing of securities by a public company is right issue. See, dear students, here right issue means issuing of the right to the existing shareholders to subscribe for the shares of a company. So, which mean to say that these shares are not offered to all the public. These are the shares which are offered to the existing shareholders only. And the existing shareholders here also can be given a right to renounce, which mean to say that they can offer for subscribing to the new shares issued under right issue, or they also can be given an option to transfer the right to subscribe for the shares on their behalf to someone else. So this is the right issue which will give an opportunity to the existing shareholders to grow along with the company. So if the company is very prosperous and when its return on investment is very huge, normally the promoters of the company or the management of the company will think of giving an opportunity to the existing shareholders to subscribe for its shares so that their loyalty to the company will be reciprocated by the management of the company by giving a option to subscribe for the shares under the umbrella of right issue. This is the third mode of issuing of shares by a public company. And when it comes to the fourth one, so when it comes to the fourth mode of issue by a public company, it is a bonus issue. Students, you all aware that bonus issue. So these are the bonus shares which are issued by a public company to its either employees or to its existing shareholders. Right shares will be normally issued to the existing shareholders only. When it comes to bonus shares, it can be issued sometimes to the employees as well. So here there is a one technical difference between the right issue and the bonus issue. In case of a right issue, all the times there will be a purchase consideration, which mean to say they have to pay for the shares whatever they are subscribing for under right issue. When it comes to bonus issue, in some cases there cannot be a consideration also. For example, in case of the existing shareholders, instead of giving a cash dividend, the company can give to them as shares in the form of bonus. So in such a case, the company will not be collecting anything from the existing shareholders as it is given in the form of shares instead of giving it as a cash dividend. So dear students, this is a very important and a very nice topic one should has to understand. So various kinds of issue of securities in case of a public company. One is through public offer, second is through private placement, third is through right issue, and fourth is through bonus issue. And when it comes to a private company where it is having a limit of number of its members, it can offer its shares with certain restrictions. So you all know that a private company cannot offer shares to a general public. So private company do have certain restrictions with reference to offering of shares. So in case of a public company, there are four modes. If you see in case of a private company, there are only three modes of issuing of securities. So the first one is a private placement. While making a private placement again, the company can offer shares to the limited number of people, and wherein the private company should be very careful after making a private placement. The number of members of a private company should not exceed the maximum number of 200. So that is to be kept in mind. And the right issue means issuing of shares to the existing shareholders only. So the capital will increase, but the number of members cannot increase and will not increase by going for a right issue. And the other one is the bonus issue. So instead of giving cash dividend, sometimes company can give the shares also to its existing shareholders, or sometimes it can offer bonus shares to its management as well. So dear students, this is a very important topic that may likely to come in your examination. If the examiner wants to test the student his a broad view of the issue of securities by a public company or by a private company, he may likely to ask this question. So you have to be very thorough with this simple and a beautiful diagram which will make you not to miss even a single point while giving a answer to the question asked for. Here is another simple diagram that also explains the same topic. So this diagram says that this tabulation says in case of a public company, what can be possible to issue, and in case of a private company, what can be possible to issue. If you see public offer, including initial public offer, further public offer, or offer for sale of securities, a public company only can do, but not a private company. As you already aware, a private company is prohibited to offer its securities to general public. Second one is private placement. Private placement means offering of securities to the people, selective people. So it is allowed both by the public company and by the private company. So the third type is that either right issue or the bonus issue of securities. It can be done by public company and private company also. And when it comes to while issuing securities, and there is some compliance which is being stipulated by Securities Exchange Board of India. These are the certain rules and regulations for compliance while issuing the shares, which is applicable only to a public company. For a listed company proposed to be listed also have to comply to it, but the same is not applicable in case of a private company. So dear students, with this you will better understand the various modes of securities offered by public companies and private companies, and what are the modes that can be done by a public company and what are the modes that can be done by a private company. Apart from that, the application of the compliance prescribed by the SEBI while issuing the shares is applicable only to a public company which is listed or proposed to be listed, but not to a private company. Right. So this is all about this topic, and now we go for the next topic. Right. The second most important topic is about the prospectus. You know that a prospectus can be issued only by a public company for issuing of securities to the general public to subscribe for its securities. So here students, the possible question is how to define the prospectus and what is the procedure and related concepts for issuing a prospectus that we are broadly going to discuss. If you see the definition of a prospectus, which is being given under section 20 subsection 70. So dear students, you don't need to remember the sections whatever that comes in the Companies Act, but there are certain sections so you have to remember. Prospectus is a broad topic and prospectus itself is a chapter for you. Hence, you need to remember the section which defines the prospectus. So, prospectus means it is any document. A prospectus means any document which is described or issued as a prospectus, which includes red herring prospectus, and the second one is shelf prospectus or any notice, circular, advertisement or other document inviting offers. See, very simple definition. Student have to appreciate and understand. Any document issued as a prospectus, which includes a red herring prospectus, shelf prospectus, or any notice, circular, advertisement, or other document inviting offers from the public for subscribing the security, for subscribing of any securities of body corporate is called as prospectus, right? So here they have given a one simple beautiful diagram which explains you what includes a prospectus. If you see prospectus which includes red herring prospectus, Red herring prospectus means it is a prospectus which consists of the highlights of a prospectus. This red herring prospectus is issued prior to the prospectus. However, whatever the rules and regulations that are complied with respect to a regular prospectus will also be complied while issuing the red herring prospectus. The only difference is that a red herring prospectus consists of highlights of a prospectus. The salient features of a prospectus are embodied in the red herring prospectus, which is issued in advance. Like before, if I say an example so that you can remember what is meant by a red herring prospectus in common man terminology. See, before releasing a movie, we will get a review, a film review, which gives the gist of the movie, the highlights of the movie. So, in the same way, the red herring prospectus will also give the highlights, the silent features of a prospectus. So, a prospectus includes a red herring prospectus. The second one is the shelf prospectus. Dear students, shelf. You know, shelf means there will be various uh, provisions, so various stages in it. So in the same way, a shelf prospectus will have a provision for more than one number of issue based on it. Say for example, during the coming 10 years, if a company wants to go for issuing of shares, once in every 2 years, it can issue a shelf prospectus for all the five issue of securities once in every 2 years. So this is for a period of 10 years, for 5 years, which is issued at once, which is called as a shelf prospectus. Shelf prospectus. However, students here, while issuing a prospectus, while issuing shares once in every 2 years in the given example, they have to issue a information memorandum in order to invite the public to subscribe for the securities of a corporate body. So this is the beauty of a shelf prospectus, which is a part of prospectus. And the another one is that a prospectus also includes a document which describes about the securities which is being offered to the public. And the fourth one is which includes even notices, circulars, advertisements, or a document inviting the public for the subscription of any securities of corporate body. So this is the definition of a prospectus and also what it includes as it is given in section 2 subsection 70 of the Companies Act 2013. So you can have a look at the what is being stated in the prospectus. A prospectus should be dated and signed. It should be dated and signed. So whatever the date on which it is signed will be considered as a date of publication of the prospectus. And the information and the various reports are also should be furnished in the prospectus. And as all these things have to be done as specified by the SEBI in consultation with the central government, right, students? And there are certain exceptions, what is not to be included in case of the certain sub clauses. And apart from that, an application, whenever it is being issued, the company has to register the prospectus with the register of companies. So the register of companies will register the prospectus before it is going to be get published to invite the public to subscribe for the shares. See, this point very clearly says that prospectus to be issued after registration and compliance with other formalities. So there is a mandatory registration and there is a mandatory provisions that are to be complied as a formalities before its publication. And a prospectus should also have a experts excluded from making a statement. Normally, in each and every prospectus, what it should include is that an expert's opinion should also be there in the prospectus. But all the experts cannot make a statement. Some of the experts are excluded. Who are excluded to make a statement in prospectus is a prospectus shall not include a statement to be made by an expert unless the expert is a person who is not engaged or interested in the formation or promotion or management of the company and has given his written consent to the issue of the prospectus and has not withdrawn such consent before the delivery of a copy of prospectus to the registrar for registration. So, such a person is excluded from making a statement in the prospectus as an expert statement. So, the person who is interested in the management of the company or the person who is being hired to issue the prospectus as a consultant or as an expert should also not make any statement in it. So these are the certain related concepts while issuing a prospectus by a corporate entity. And the company should also mention certain compliances and formalities before it is going to publish the prospectus. And the company has to deliver the prospectus for registration within the stipulated time, and it also have to file the required documents which is being prescribed under the section with the registrar before publishing the prospectus in the newspaper. These are some of the related concepts while issuing a prospectus. So the second topic, the definition of a prospectus and the procedural aspects with related concepts could be a likely question. Here, the students are expected to define what is meant by prospectus and also and what are the related procedure and concept, which mean to say before publishing that prospectus to invite the public to subscribe for shares, the company has to register the prospectus with the various reports and informations with the register of companies. And once this is being registered with the registrar, within a period of 60 days, the company has to publish the prospectus inviting the public to subscribe for its securities. And these are the certain related topics, dear students, one needs to understand. So, the third topic under the chapter is what are the contents of a prospectus. So, earlier in the second topic, we studied what a prospectus includes, which means to say what a prospectus includes is different from the contents of prospectus. Students should not get confused. What a prospectus includes means it could be a red herring prospectus, or it could and a shelf prospectus, or any document, or notices, circulars, advertisement, or any other document. All these are included in the prospectus, but the contents of the prospectus is different. So the contents of the prospectus may likely to be asked as a separate question in your examinations. So dear students, this diagram will explain you very in a simple and understandable way. The students can make it each of the line item given here as a one paragraph, and you can give a beautiful answer in a couple of paragraphs if a question comes asking you about what are the contents of a prospectus. If you see here, the point first one is a prospectus must be dated. So whenever a prospectus is issued, it should be dated, and which mean to say that the date of prospectus is considered as a date of publication of the prospectus. So the publication date and date of the prospectus is considered one and the same. And second point under the same is that it should be signed. And who is to sign? It should be signed either by the directors or the persons who is proposed to be the directors, or an attorney having the power to sign on the prospectus. So any one of these three categories of people can sign on a prospectus. And when it comes to the third point, information under 26(1). So information under 26(1) means, 26 subsection 1 means a prospectus to get it published and to get it signed and offer the public to subscribe or purchase the shares of a body corporate. First thing they have to do is that it should get the prospectus registered with the register of companies by complying to all the rules and regulations as prescribed by the Securities Exchange Board of India. So the information under section 26 subsection 1 should mention in the contents of prospectus that stating that the prospectus has been registered with the register of companies of the company where its jurisdiction exists. And the fourth point says the reports under 26(1). There are certain reports which has to be included in the prospectus. So the second area is that the expert report. Students, every prospectus should have an expert report. This is the guiding force for the subscribers to purchase shares in any company. So the expert should be a neutral person. The expert should rate the company, how it is going to perform, and what will be the advantages and disadvantages, or what are the merits and demerits, and what are the positive side and the negative sides, and what are the strengths and the risks of a company will be discussed and reported by the expert in the prospectus. So this report will carry a lot of weightage, and it is very significant to the shareholders who are going to purchase the shares. So the person not engaged in the formation, which means to say the person whoever is being giving the expert report to the prospectus should not be engaged in the formation of a company, and also he was not given his written consent to give services as an expert to publish the prospectus of the company, and the consent which was given, which was filed with the registrar, has not been withdrawn. So such a person cannot give an export report to the prospectus. And the third aspect is that above points mentioned in the prospectus, all these points should also be mentioned in the prospectus. Dear students, and when it comes to the last part of the contents of a prospectus, to say it should have a cover page, and a copy is delivered to the register of companies, which mean to say the prospectus which is published should also be delivered to the register of companies to see that what was registered with him and what is being published, whether the both are one and the same, will be verified by the register of companies. So that is the reason the published prospectus should also be delivered to the register of companies for his record and information. And the list of documents submitted to the register of companies at the time of registering the prospectus before it is getting published should also be mentioned in the prospectus in detail. So dear students, this is a possible question for you about the contents of your prospectus. If you can write this answer with this simple and beautiful, legible and easily understandable flow chart, you will have definitely get the fantastic marks. So these are the three topics that I want to give in this present presentation, and I hope students will understand, as it is a very simple and easiest topics for every student, irrespective of the stream from which they are coming in to study the CA course. With this, I thank you all, and I advise you all to listen to the future sessions on prospectus chapter. Thank you.